Michael Richardson, the attorney who defended three Fortune 500 CEOs and one, just quit live on NBC News during a primetime interview. Not because of money, not because of politics. He said it himself. I cannot, in good conscience, continue representing someone who refuses to follow legal advice. I'm Elizabeth Carter, and this is the story nobody wants you to understand. Before we go any further, I need you to do something right now. Hit that subscribe button, click the notification bell, leave a comment below telling me if you've ever seen a lawyer quit on live television. Share this video with everyone you know. This is the only official channel delivering independent investigative journalism. What I'm about to show you is happening in real time across Washington, and it's spreading. Richardson built his reputation over 30 years defending impossible cases, corporate fraud scandals, political corruption trials, constitutional challenges that made Supreme Court history. His legal team won cases other firms wouldn't touch. They charged premium rates because they delivered results, and now they're walking away. Here's what happened during that NBC interview. Richardson sat across from Lester Holt discussing legal strategy for an upcoming trial, standard media appearance. Then Holt asked a simple question about client cooperation. Richardson paused. He looked directly into the camera. Then he said those words that changed everything. I cannot in good conscience continue representing someone who refuses to follow legal advice. The interview ended immediately. Richardson walked off the set. His law firm issued a statement 2 hours later confirming his resignation from the case. No transition plan, no professional courtesy period, just gone. Think about that. A man who spent 3 decades building an unbreakable reputation just torched it on live television. This isn't about one angry attorney having a bad day. Richardson's resignation follows a pattern. 3 other lawyers from his firm quit in the past month. The entire litigation strategy team disbanded. Junior associates transferred to other departments. Something is systematically destroying the most successful legal defense operation in Washington, and it gets worse. What I'm about to show you reveals how attorney resignations connect to a much larger breakdown happening inside our justice system. When lawyers won't take cases, when legal teams collapse, when the foundation of representation itself starts cracking, everyone's constitutional rights are at risk. Let me show you exactly how we got here. Let me tell you exactly who Michael Richardson is, because his reputation makes this resignation impossible to ignore. Richardson graduated top of his class from Harvard Law in 1994. He clerked for Supreme Court Justice Anthony Kennedy. He built the litigation department at Morrison & Associates from 3 attorneys to 47 in 15 years. His win rate in federal court is 86%. That is not normal. Most defense attorneys consider 60% exceptional. His client list reads like a Fortune 500 directory. He defended Enron executives during the accounting scandal. He represented pharmaceutical companies in class action lawsuits worth billions. He won constitutional challenges that other firms called unwinnable. Corporate executives paid his firm $1,200 per hour because Richardson delivered results when careers and companies hung in the balance. Think about that track record. This is not someone who quits because a case gets difficult. This is not someone who walks away from premium fees. Richardson built his entire professional identity on defending the indefensible. But here's what makes his resignation truly unprecedented. Richardson didn't just quit alone. Jennifer Walsh, senior associate specializing in criminal defense, submitted her resignation 3 weeks ago. David Chen, partner in charge of constitutional law, left 2 weeks ago. Maria Santos, the firm's leading appellate specialist, departed 1 week ago. The entire litigation support team disbanded over the past month. Translation: the most successful legal defense operation in Washington just collapsed from the inside. I called Morrison & Associates yesterday. The receptionist told me they are not taking new criminal defense cases. They referred me to 3 other firms. When I asked about existing cases, she said the firm cannot comment on ongoing litigation. Translation: they are abandoning ship in the middle of active trials. Dr. Sarah Mitchell, who studies attorney ethics at Georgetown Law School, told me in an interview yesterday, I have never seen anything like this in 30 years of analyzing legal profession patterns. When attorneys resign from high-profile cases, they typically provide transition periods, file motions for substitution, ensure continuity of representation. Mass resignations without transition plans suggest something fundamentally incompatible with professional obligations. Let that sink in. These attorneys didn't just disagree with strategy, they didn't just want higher fees, they walked away from million-dollar retainers and destroyed professional relationships built over decades. Legal experts are calling it unprecedented. But wait, there's something they're not telling you about what really caused this mass exodus. The American Bar Association requires attorneys to withdraw from representation in only three circumstances: client refuses to pay fees, attorney develops conflict of interest, or client demands actions that violate legal ethics. Richardson and his team had guaranteed payment contracts. No conflicts of interest existed. That leaves only one possibility. Their client demanded they violate legal ethics. And here's where it becomes undeniable. I obtained copies of internal communications from Morrison and Associates through a source familiar with the matter. These emails show escalating tensions between the legal team and their client over trial strategy. The attorneys repeatedly advised following standard legal procedures. The client repeatedly demanded strategies that, according to the emails, would constitute obstruction of justice and contempt of court. One email from Richardson to his litigation team, dated 2 weeks before his resignation, reads, "We cannot and will not pursue strategies that violate our professional obligations, regardless of client pressure or financial incentives." Translation: their client was asking them to break the law. Now watch the domino effect that destroyed the most successful legal defense team in Washington. First domino: client demands strategy violating legal ethics. According to internal emails I obtained, the client repeatedly pressured Richardson's team to file motions they knew would be frivolous. Federal court rules explicitly prohibit attorneys from making arguments without good faith legal basis. The client wanted them to claim executive privilege in situations where no privilege existed. The client demanded they object to evidence collection that was clearly constitutional. Richardson's team explained these strategies would result in sanctions, potential disbarment, and criminal contempt charges. The client's response, according to one email: "I don't care about your professional rules. I care about winning." Second domino: attorneys push back, client doubles down. Jennifer Walsh documented the escalation in a memo to the litigation team dated 3 weeks before the mass resignations. She wrote, "Client has rejected every piece of legal advice we have provided regarding trial strategy. Client insists we pursue tactics that would constitute obstruction of justice. When we explained the potential consequences, client responded that we are being paid to follow instructions, not give advice." Translation: the client viewed attorneys as employees, not legal counselors. David Chen sent an email to Richardson stating, "This is no longer about legal representation. This is about client demanding we become accomplices to criminal activity. I cannot ethically continue." Think about that. A partner with 15 years at the firm called continued representation criminal accomplice behavior. Third domino: internal communications show escalating tensions. Maria Santos, the appellate specialist, documented attempts to find middle ground solutions. Her emails show she proposed alternative strategies that would satisfy client objectives while maintaining legal ethics. The client rejected every compromise. One email from Santos reads, "Client told me directly that if we are not willing to do whatever it takes, including breaking rules, then we are useless. That is not legal representation. That is conspiracy." Richardson attempted intervention meetings with the client. According to calendar records, he scheduled 5 separate sessions to discuss ethical boundaries and professional obligations. The client attended only one meeting. Richardson's notes from that meeting, which I obtained through a source familiar with the matter, show the client stated, "Ethics are for lawyers who lose cases. I hired you to win by any means necessary." Fourth domino: fee payment delays create financial pressure. While this crisis unfolded, the client began delaying payment of legal fees. Morrison and Associates typically receives payments within 30 days of billing. During the final month before the resignations, payments stretched to 60 days, then 90 days. The firm had advanced over $2 million in case preparation costs. Outstanding invoices totaled $3.7 million. Translation: the client was using financial leverage to force compliance with illegal strategies. Richardson's accounting department sent multiple payment demand letters. The client's response, according to copies I obtained: payment schedule depends on legal team cooperation with trial strategy. Full cooperation ensures prompt payment. Continued resistance affects payment timeline, that is, extortion. Fifth domino, public statements contradict legal strategy. While Richardson's team prepared legitimate legal defenses based on established precedent and constitutional law, their client made public statements that directly contradicted their strategy. The client held press conferences claiming evidence was fabricated. The client posted social media statements attacking the credibility of witnesses. The client gave interviews undermining the very legal arguments his attorneys were preparing. Dr. Mitchell from Georgetown explained the impossible position this created. When clients make public statements that contradict legal strategy, attorneys face ethical violations if they proceed with arguments their client has already undermined. The client essentially sabotaged his own defense while demanding attorneys continue representation. Richardson sent a final email to his client one day before his NBC resignation. The email stated, "Your public statements have made our prepared legal strategy impossible to pursue without violating court rules and professional ethics. We cannot represent you effectively when you actively undermine legal arguments we are required to make in good faith." The client's response, "Then find new arguments that match my statements." Translation: the client demanded attorneys change legal reality to match his public narrative. That final exchange explains everything. Richardson didn't quit because he was frustrated. He didn't quit because he disagreed with trial strategy. He quit because continued representation would require him to commit crimes. And here's what nobody is saying out loud. This breakdown extends far beyond one legal team. According to American Bar Association records I obtained, attorney withdrawal motions in high-profile political cases have increased 400% in the past 6 months. Legal experts are warning that when clients systematically pressure attorneys to violate ethics, the entire foundation of legal representation collapses. Dr. Rebecca Torres, who studies constitutional law at Yale, told me, "We are witnessing the breakdown of attorney-client privilege, professional ethics, and court procedures simultaneously. This threatens every citizen's right to effective legal counsel." But wait, there's something they're not telling you about who else this affects. Let me tell you about Jennifer Walsh, because her story shows you exactly what this crisis costs real people. Walsh graduated from Columbia Law School in 2018. She joined Morrison and Associates as a junior associate with dreams of becoming a federal court litigator. She worked 80-hour weeks for 5 years, building expertise in criminal defense. She passed the bar in 3 states. She won her first federal case last year defending a whistleblower against retaliation charges. Walsh told a colleague in an email I obtained, "I didn't go to law school to compromise my ethics. I became an attorney to uphold justice, not to help clients circumvent it." She resigned from Morrison and Associates on December 15th. She had no other job lined up. She walked away from a $200,000 salary and partnership track position. She now works at a legal aid clinic, making $45,000 per year, helping domestic violence survivors. Let that sink in. Walsh sacrificed her career trajectory rather than violate professional ethics. That is the human cost of this systemic breakdown. And Jennifer Walsh is not alone. David Chen built his reputation over 12 years as Morrison and Associates constitutional law specialist. He argued cases before federal appellate courts. He taught constitutional law as an adjunct professor at Georgetown. His expertise in executive power limitations made him one of the most sought-after attorneys in Washington for political cases. Chen told his wife, according to a source familiar with their conversation, "I can't look our children in the eye and tell them I maintained my integrity while helping someone destroy the legal system their generation will inherit." Chen left Morrison and Associates and joined a nonprofit organization defending voting rights. His salary dropped from $400,000 to $90,000 annually. He gave up equity partnership worth an estimated $2 million over 10 years. Think about that financial sacrifice. Chen chose professional ethics over financial security for his family. Senior partner Maria Santos faced an even more devastating choice. Santos spent 15 years building appellate expertise. She argued 12 cases before circuit courts and won 10. She was being considered for federal judgeship nominations. Her resignation from Morrison and Associates effectively ended her judicial prospects. Santos explained her decision to a former colleague. "When I took my oath as an attorney, I swore to uphold the Constitution and legal system. I cannot participate in undermining the very institutions I swore to protect." Translation: These attorneys chose professional suicide rather than legal collaboration with client demands. But here's what makes this crisis truly dangerous. The financial impact extends far beyond individual attorney decisions. Small law firms across Washington are refusing to take high-profile political cases. According to interviews I conducted with 7 criminal defense attorneys, the financial risk of client demands for unethical strategies has made these cases uninsurable. Legal malpractice insurance companies are excluding coverage for cases involving clients who publicly contradict attorney strategies or demand tactics that violate professional ethics. Robert Kumar, who runs a 12-attorney firm specializing in white-collar defense, told me, "We can't afford to take cases where clients might demand we commit professional suicide. Our malpractice insurance premiums would become prohibitive, and our reputation would be destroyed if we had to withdraw mid-trial." Translation: fear of ethical violations is pricing legal representation out of reach. Kumar's firm typically charged $300 per hour for federal criminal defense. They now require $500,000 retainers upfront for political cases, with additional clauses allowing immediate withdrawal if clients demand unethical strategies. Most potential clients cannot afford these protective measures. The American Bar Association documented this trend in a report released last month. Attorney withdrawal rates in high-profile cases have increased by 400% since January. Legal aid organizations report receiving 50% more applications from attorneys seeking lower-paying but ethically clear positions. Dr. Sarah Mitchell from Georgetown warned me about the broader implications. When experienced attorneys abandon lucrative practices rather than compromise ethics, we lose institutional knowledge and expertise. Junior attorneys learn that ethical principles require career sacrifice. This creates a brain drain from the legal profession exactly when constitutional expertise is most needed. And here's the irony that should make everyone angry. The legal system was designed to ensure every citizen receives competent representation regardless of their circumstances or accusations. The Sixth Amendment guarantees this right. But when clients systematically pressure attorneys to violate ethics, they destroy their own constitutional protections. Jennifer Walsh, David Chen, and Maria Santos upheld the legal system by leaving it. They protected constitutional principles by sacrificing their careers. They maintained professional integrity by accepting financial devastation. That is not how the justice system should work. That is how the justice system breaks down. And this breakdown is spreading beyond political cases into corporate law, criminal defense, and civil litigation. When attorney-client relationships become adversarial, when professional ethics require career suicide, when legal representation becomes financially impossible, everyone's constitutional rights suffer. But wait, there's something they're not telling you about where this leads. Here's what legal experts are warning about where this crisis leads and why it should terrify every American. Professor Janet Morrison, who directs the Constitutional Law Institute at Harvard, told me in an interview yesterday, "When attorneys won't take cases because clients demand unethical behavior, the justice system doesn't just fail individual defendants, it fails democracy itself. Without competent legal representation, constitutional protections become meaningless words on paper." Think about that. The Sixth Amendment guarantees legal counsel, but guarantees mean nothing when attorneys cannot ethically provide representation. This isn't the first time in American history that attorney-client relationships have collapsed under institutional pressure. During Watergate, multiple law firms refused to represent Nixon administration officials after clients demanded strategies that violated legal ethics. During the McCarthy era, attorneys faced similar pressures when clients wanted them to pursue tactics that compromised constitutional protections. But here's what makes the current crisis unprecedented. Previous breakdowns involved individual attorneys making ethical choices about specific cases. Today's crisis involves systematic pressure across multiple law firms, multiple practice areas, and multiple jurisdictions simultaneously. Dr. Rebecca Torres from Yale documented this pattern in research published last week. Her study tracked attorney withdrawal patterns across federal courts in 12 major cities. The data shows coordination between different legal teams facing identical client pressures. Torres concluded, "This suggests organized effort to pressure attorneys into abandoning professional ethics rather than isolated incidents of difficult clients." Translation: someone is systematically testing the breaking point of legal representation. The Bar Association held an emergency meeting in Chicago last month to address what they called an unprecedented crisis in professional ethics. I obtained minutes from that meeting through a source familiar with the proceedings. Association President Margaret Chen warned attendees, if current trends continue, experienced attorneys will abandon high-profile practice areas entirely. This creates a two-tier justice system where only clients willing to accept ethical representation can obtain competent counsel. Let that sink in. We're heading toward a justice system where constitutional protections depend on client behavior rather than legal guarantees. Academic researchers at Stanford Law School published a study tracking this breakdown across different case types. Professor David Kim found that attorney withdrawal rates have increased in corporate fraud cases by 200%, in political corruption cases by 400%, and in constitutional challenges by 300% over the past 8 months. Translation: this crisis extends far beyond political cases into the foundation of legal representation itself. When I asked Professor Kim what happens when representation becomes impossible to provide ethically, he gave me an answer that should alarm everyone. Clients who cannot obtain competent counsel either represent themselves, accept incompetent representation, or find attorneys willing to violate ethics. All three outcomes undermine constitutional protections and legal system integrity. Here's the comparison that explains why this matters. During the 1970s constitutional crisis, attorneys made individual ethical choices about specific client demands. The system adapted because most attorneys maintained professional standards while isolated cases involved ethical conflicts. Today's crisis involves systematic pressure designed to force attorneys to choose between professional survival and ethical compliance. When that choice becomes universal across practice areas, the legal profession cannot adapt. It breaks down. Dr. Morrison from Harvard explained the cascading consequences. When senior attorneys leave practice rather than compromise ethics, junior attorneys lose mentorship and institutional knowledge. When law firms refuse cases due to ethical risks, client pools shrink and legal expertise concentrates in fewer hands. When bar associations cannot enforce professional standards because clients systematically demand violations, the entire regulatory framework collapses. And here's the warning that should make everyone pay attention. This pattern is spreading internationally. Legal professional organizations in Canada, the United Kingdom, and Australia report similar increases in attorney withdrawal rates when clients demand strategies that violate professional ethics. Professor Elena Rodriguez, who studies comparative legal systems at Oxford, told me, what we're observing in the United States appears to be a coordinated test of legal system resilience. If successful, this model could be exported to any democracy where attorney-client relationships provide constitutional protections. Translation: this isn't just about American legal representation. This is about whether democratic legal systems can survive systematic ethical pressure. But here's what nobody is saying publicly about who benefits when legal representation becomes impossible to provide ethically. When attorneys cannot represent clients effectively, cases get delayed, dismissed, or decided without proper advocacy. When constitutional challenges cannot be mounted due to attorney withdrawal, unconstitutional actions go unchallenged. When legal expertise becomes unavailable due to ethical conflicts, complex cases default to outcomes that favor whoever can operate without legal constraints. That is not justice. That is the systematic destruction of legal protections that democracy requires to function. And this destruction is accelerating. So here's what we know. Michael Richardson's live resignation on NBC wasn't about one frustrated attorney having a bad day. It was the public collapse of a legal system under systematic pressure to abandon constitutional protections. We trace the domino chain from client demands for unethical strategies to mass attorney resignations. We documented the human cost as experienced lawyers chose career suicide rather than professional ethics violations. We revealed the spreading crisis that threatens every citizen's access to competent legal representation.